Hello, my name is Brianna Washington.
And my name is Johanna Weiman, and today this is our presentation number 2 for our class of Legal Research Writing 2.
This is our question for the presentation for our jurisdiction in North Carolina. Casey sues her boyfriend's cousin for accidentally running over her foot with his car. The cousin serves admission requests, one of which asks her to admit that she was drunk at the time. Casey's lawyer gets behind schedule and doesn't respond until 38 days later. The court deems all of the requests automatically admitted. Casey lawyers knows the jury will see that admission. But in an effort to counter it, he also wants to introduce evidence that Casey's religion forbids her from consuming alcohol. Can the lawyer do that?
Okay, so for this one, our jurisdiction is North Carolina, state law only, and our procedural rule is Rule 36, and it covers admissions. So our first step that we did was go on to Westlaw, and we'll start with the home page right here. And our jurisdiction is North Carolina, so make sure you select that. And we typed in Rule 36.
It was much easier, and it pulled right up.
And so this is a statute, so we went down to statutes and we selected that one. And here we have the rule right here.
And the request for admission is a party may serve upon any other party a written request for admission for purpose of the pending action only of the truth of any matters within the scope of Rule 26B. The matter is admitted unless within 30 days after service of the request or within such shorter or longer time as the court may allow.
The party to whom the request is directed serves upon the party requesting the admission a written answer or objection addressed to the matter, signed by the party or by his attorney, but unless the court shortens the time, a defendant shall not be required to serve answers or objections before the expiration of 60 days after service of the summons and complaint upon him. If objection is made, the reasons therefore shall be stated. The answers shall specifically deny the matter or set forth in detail the reasons why the answering party cannot truthfully admit or deny the matter.
A denial shall fairly meet the substance of the requested admission, and when good faith requires that a party qualify his answer or deny only a part of the matter of which an admission is requested, he shall specify so much of it as is true and qualify or deny the remainder.
So the first step we took after finding our rule and as a statute, we decided to look in Westlaw under Rule 36. So since our thing deals with requests for admission, this is the one we pulled up, but I will show you how I got to it. I searched admission request in the state of North Carolina, pressed search, and found it. Let me go to the cases. There's a lot of search results. And I went through the search, and I found it was number 3. And in this one, I have it highlighted.
And the synopsis of the case is staffing company brought action against the healthcare company and its parent company allegedly breach of contract, quantum merit, and unfair and deceptive trade practice. The Superior Court, Guilford County, Michael E. Helms Jr., found that the defendants had failed to respond to requests for admission, deemed each of the requests admitted, and granted staffing company partial summary judgment.
In this case also, further down, the opinion was filing an unverified answer to a complaint does not constitute a response to request for admission, even though some of the matters addressed are identical. On September 17, 2003, both parties filed motions for summary judgment. At the hearing of those motions, Judge Michael E. Helms found that defendants had failed to respond to plaintiffs' request for admissions and deemed each of the requests admitted under Rule 36A of the Rules of Civil Procedure. Immediately following the trial court's ruling granting partial summary judgment in favor of the plaintiff, defendants made an oral motion pursuant to Rule 36B requesting the court relieve them of the effect of not responding to the request for admissions. The trial court denied the defendant's motion. So the reason I decided to use this case was in the presentation, Casey's lawyer realizes that after he didn't respond until 38 days later, the court would deem all of the requests automatically admitted since he surpassed the 30 days that is allowed by the statute. The second case that we pulled up was J.M. Parker and Sons. For this one as well, let me go ahead and put the right search parameters in. North Carolina. I also did admission request for this one. There wasn't a lot of terms and connectors used because of the fact that it's a pretty simple search. And this one, it was actually the first case that came up. So we looked through this as well as we looked through all the rest of the ones. And we'll go ahead and zoom this one in for everyone to view better.
Supplier brought action against customers seeking to recover for goods sold and delivered. The District Court, Brunswick County, William F. Fairley Jr. granted supplier's motion for summary judgment and denied customers' motion for permission to respond to requests for admissions. Customers appealed. This case arises from the attempt by plaintiff J.M. Parker and Sons, Inc., to recover the principal amount of $71,662.79 for goods sold and delivered to the defendants. No other action or filing in the case by either party occurred until April 26, 2007, when plaintiff mailed the first two sets of requests for admissions to the defendants. Counsel at address at Charlotte, not to the Calabasas address listed on the defendants' March 13, 2006 answer. Defendants never responded.
Further down in this case, we have where it states, where one party fails to timely respond to another's request for admissions. So in Rule 36, it says, the 30-day rule. The facts in question are deemed to be judicially admitted under Rule 36 in the North Carolina Rules of Civil Procedure. Rule 36, I really like this part of the case. This is why I decided to pull it up. Rule 36 means precisely what it says. In order to have requests for admissions deemed admitted, a party must respond within the period of the rule if there is any objection whatsoever to the request. So, the period of the rule, of course, in 36 is 30 days to respond and 60 days to object. So we'll go back to our case where it said, where he responded 38 days, so obviously that is going to be automatically admitted because he didn't respond in 30 days. And then the 60 days, he did fit in that time limit because he decided to do 38 out of 60. So that was a good case to state that there is a period of the rule where it's 30 and 60 days. And I think that was the only thing that I decided to cover in this. So the last part of the question says that he wants to introduce evidence that Casey's religion forbids her from consuming alcohol. Can he do that?
No.
So the way that we found this case was we looked on Westlaw and we really couldn't find anything, any Boolean terms or connectors. We searched everywhere. So we decided to go to Google Scholar. So in Google Scholar, we input case law, and we had to make sure we selected the right court. So we decided to go to North Carolina and press done. And in here, we put religion. One of the things that says religion forbids alcohol. So we put prohibit consuming alcohol. And in this, we didn't find anything. So what we did,
we went back to religion forbids alcohol.
And we looked through all the results, and we found State versus Madej. So we thought that since we found this on Google Scholar, that maybe we would find the same thing on Westlaw. So what we did was we took the case citation, we went and copied and pasted that, and we'll put this case citation right in Westlaw, and it leads us directly to the one that we were found on Google Scholar. So in this case,
it talks about the religion part. Mainly, no religion forbids you to not drink alcohol. Of course, each religion states different reasons on why you shouldn't consume alcohol, but it never forbids you from drinking alcohol. So meaning that if the woman in our case, in our question, was drinking alcohol, it wouldn't be relevant to our case, because if she wants to drink it, she can. And in this case, it says religious organizations generally do not prohibit their members from consuming alcoholic beverages. However, no one will seriously contend that they do not teach against the consumption of alcoholic beverages by their members, which is correct. Every religion do not prohibit it. Now, they tell them not to because they don't want them to for certain reasons. So that part of our case, where the lawyer, he wants to introduce evidence about forbidding because of her religion, that's not gonna stick, because no religion, as the rule said, is gonna say that it forbids her.
And of course, the original admission request that was asked for, one of them asked her to admit that she was drunk at the time, so he thought that he would go ahead and introduce evidence that her religion forbids her from consuming alcohol. Even if it were to forbid her, doesn't mean that she wasn't. So the evidence wasn't very relevant. So let's go ahead and talk about our ending written response to this. This is how we feel about the case and what we hold after reviewing case law as well as our procedural rule.
Procedure Rule 36 states that a matter is admitted unless the opposing party responds within 30 days that the admission is served. The party also has 60 days after the service of the admission to object. In this case, Casey's lawyer made an attempt to object after 38 days, which falls within the time limit. Casey's lawyer is able to make an objection and introduce evidence that her religion forbids the consumption of alcohol. However, the evidence is not relevant to the case and does not fairly meet the substance of the requested admission. Overall, the evidence doesn't support the claim in the original request for admission.
Okay, so the citations for our binding sources that you saw today would be our procedural rule, which would be R Civ P 36. Our next one would be Excel, the two parties Excel Staffing Service, Inc. versus HP Reedsville, the 616th volume of the Southeastern Reporter, 2nd edition, page 349, decided in 2005. The next one would be J.M. Parker and Sons, Inc. versus William Barber, Inc., the 704th volume of the Southeastern edition, 2nd edition, pages 64 and 68, decided in 2010. And the last case, State versus Madej, the 140th volume of the Southeastern 2nd edition, 325 and 328 were the pages, and decided in 1965. Thank you guys for watching our presentation, and please leave any comments or questions below. Thank you.
Thanks.